And if my camera person could just pan there, they have already arrived at this place, and maybe they will be shedding light in what they expect the president to be telling us this morning in regard to what happened here. And you remember there was a call by the president when he visited this place that they could be relocated. And some of those we spoke to are actually not in the intention of returning to this place. And just giving you just a scope of the scenario as it is, just on the escarpment there, somewhere up there is where we had the flash flood, and it was quite catastrophic. And just below, where you can see just at the top of those houses, there's a deep gully, and it was full of water, and that is what swept quite a large village here at Kamushera, which is just stretching across over. Actually, up there is quite very scenic as you view what is like in my Mahio estate. And just maybe I could speak to a lady here. Nieleze jina lako na unieleze wewe uliathirika kivipi, na wakati naibu rais atakapofika hapa ungetaka kusikia nini kutoka kwake?
Naitwa Tabitha Wanja Mwangi. Niliadhika kutupa familia ya watu 8, na venye tu naweza omba maadhe na dad wapate mahali pa kuishi. Tulikuwa tunaishi kulent, but naweza taka wakuwe pali wanaweza kwao tuwe tukienda kuwatembelea. But kama tulikuwa na mahali tulikuwa yani kama tungekuwa na kwetu, hiyo maneno yetu haingetukuta. Sasa venye naweza omba ni serikali tu itusikilie huruma tupate mahali ya kuishi.
Ungetaka kurudishwa huko tena mahali ulikuwa, kama serikali itaamua msetuliwe pale, ungetaka kurudi kwa hiyo area?
Hapana, siwezi taka upande huyo tena, juu hujui kama hiyo maji itakuja tena. Tunajua mvua ni ya Mungu. Sasa but siwezi kuwa tu karibu na maji.
Sasa kidogo mzee, karibia hapa unieleze jambo. This gentleman Stanley lost 8 of his family members, and he was the worst affected, and perhaps let's hear what he has to say. Mzee, pole kwa yaliyojiri, yaliyokufika. Tueleze jina lako na hali ilikuwaje, na ungetaka nini kutoka kwa serikali?
Mimi naitwa John Mwangi Maura. Na ningependa serikali tusaidie pahali pa kuishi. Ningeomba tafadhali tupatie pahali pa kuishi.
Uliathirika, watoto 8 wako walipoteza maisha hapa. Ungetaka serikali kufanya nini, na ni matayarisho gani tayari sasa ambayo tayari imekamilika kufuatia ili mkaweze kuwapea wale wandani wako maziko yanayostahili?
Watatusaidia na majaneza na kaburi na kulipia sisi mpaka hospitali.
Mama, pole kwa aliyokupata. Tueleze jina lako. Umesema ulikuwa hospitali.
Majina langu naitwa Mary Mudhoni Mwangi. Nilikuwa hospitali nikakutwa na hiyo mkasa wa maji, na ningeomba tu serikali watusaidie mahali ya kukaa. Juu kutoka 1992 bila tulitoka huko hatujawahi pata mahali ya kukaa. Tuna renti tu na mashida mingi, hatuna mahali. Lakini nimepoteza watoto 8. Ningependa tu serikali watusaidie mahali ya kukaa. Familia yetu yote hawana mahali ya kukaa. Juu tuliachiliwa hivyo tu. Tusaidiwe tu mahali ya kuishi.
Ulikuwa hospitali kwa sababu gani, na ilikuwa vipi, na sasa uko hapa leo?
Nilikuwa hospitali juu ya kugongwa kifua. Niligonga kifua na mguu. Ndio nilikuwa hospitali. Nikasikia nafuu, ndio nikaletwa hapa tu kwa ile camp. Ndio sasa tukakampu huko.
Labda mwito wako kwa serikali kwa sababu ya maeneo kama haya ni upi? Kwa sababu Waziri Kindiki Kifuri alikuwa amesema wale wote wako katika eneo hili waweze kuondoka pia.
Rudia nisikie.
Ungetaka Waziri wa usalama wa ndani Kithure Kindiki alikuwa ameagiza wote walioko katika eneo hili waweze kuondolewa. Wewe ungependekeza kitu gani kutoka kwa serikali?
Ungependa tuondolewe, tutafutiwe mahali ya kujenga. Tujengewe.
Asante. Sister, songea karibu. Tueleze ikiwa wewe ni mwathiriwa na ilikuwa vipi na ungependekeza mambo gani kutoka kwa serikali. Ni sawa tu. Asante.
Mimi ningependa tu.
Jitambulishe kwanza.
Mimi naitwa Naomi Wanjiro. Wenye waliathiriwa ni sisters zangu, mama yangu. Na ningependa tu wasaidiwe, kama mama yangu abaiwe shamba, ajengewe, at least aache kuwa rento. Madada zangu hata wao wasaidiwe, naweza furahia sana na nitashukuru.
Wacha tumalizie na jamaa hapa. Ndugu, karibia tu hapa, unieleze jina lako na uliathirika kivipi na labda kitu gani ungependa kusikia kutoka kwa serikali hii leo tunapomtarajia naibu rais.
Okay, mimi naitwa Jeremiah Macharia. Mimi ni mwathiriwa sababu huyu ni shangazi yangu ambaye ni dada ya baba yangu. Kile ningesema tu ni ya kwamba serikali ishughulikie hawa waathiriwa, sababu mambo yaliyofanyika yanaonekana ni ukweli, si kitu ya kusema tu ni kitu ilifanyika ambayo ilikuwa imepangwa, ni kitu ilifanyika tu kulingana na mambo ya Mungu. Ningeomba tu serikali ingilie kati, iwasaidie ili waone kuwa kwamba serikali na wajari. Yes.
Athari zingine za baadaye ya eneo hili labda kiuchumi zimeathirika kivipi kutokana na yale ambayo yalijiri hapa? Mwingine alitueleza kwamba value ya shamba pale imerudi chini sana. Sijui, maybe on that scope, what can you say?
Vile ningesema ni ya kwamba sioni kama kuna mtu anaweza rudi mahali pale, sababu maybe ukikaa unaona in future yale maji yanaweza yakarudi. So ningeomba hata kama ni kuhamishwa, wahamishwe eneo hilo na serikali itafute pahali pengine, sababu itakuwa ni ngumu sana mtu kurudi mahali pale, na mambo yaliyofanyika utakuwa tu ukisikia kitu jambo lolote unapatwa na mshtuko.
Asante. Nashukuru sana. Stanley, that is just one group that has been resettled here in Mai Mahiu on rented apartment. And just across over to the other side, we have some other group that was resettled there. They are actually holding at a children's shelter, which was initially a children's shelter, but now it is power beyond boundaries, where prayer beyond boundaries, where what is the name? Ngunjiri, Madam Ngunjiri just gave that facility to the government so that they can have a safe haven there as they wait for resettlement from this place. And those we spoke to initially say that they will not wish to get back there because they are physically and psychologically tormented by the advent of what happened here. And you remember this place, especially Mai Mahiu, to the lower side of it is where we have so much government infrastructure, that is the SGR, and where the president actually launched a few projects just months and days ago. And actually it is a place that is vast and very vast on heavy and great government projects. And with this coming into place, it is at that time when the government has to take big consideration and on how this water flows from the hills there, and where my camera person to the other side is Mount Longonot. All of that water percolates just down below around here, and sometimes it heads to Kajiado and Narok sides, where we have had stories of devastating decrease of destruction of flash floods. We will be keeping tabs from this locality to ensure that we bring to our speed whatever is developing to our viewers on this end, and what the government has to say to the people of Kenya in regard to what has been going on. And it is by luck, this is the third day that this place has not experienced any rains ahead of anticipated reopening of schools, that is next week. Stanley, I will take it back to you for more discussion. From my end, that's it.
Thank you very much, Willie Dennis Njiru from Naivasha, the Naivasha correspondent. We'll be getting back to you when Deputy President Rigathi Gachagua visits and arrives in that area, and just telling you what he will be saying. Now, let's get into our conversation for today. for the Legal Thursdays, and there is one of those conversations that really touches quite a number of people out here. And just joining us for this conversation, not a new face to us, Evans Dong, a lawyer. Karibu sana.
Thank you so much, Stanley.
Matters whole child custody and everything is one of those conversations that really continue in different parts of the society, and also and mostly of the whole digital platform. So it's one of those conversations that should people really need the whole tips on the same. And before we, you can tell us, first of all, the whole background of it. In the legal lands, what does child custody really mean, and what kind of laws really, the provisions of laws that guide the same?
Okay, thank you so much, Stanley. The Kenyan legal regime, especially on family law generally, puts emphasis on two very important laws. The Constitution of Kenya at Article 53 of the Constitution entrenches a very pertinent concept when you are dealing with children matters, the concept of the child best interest, which ordinarily would mean that in all matters relating to a child, the best interest of the child will always take preeminence over any other consideration when you are dealing with a child. Mm-hmm. Again, that very same principle is entrenched in the Children's Act of 2022, an act that has received amendments after a very long time. Yeah. And now we have a refined Act of 2022 that has come on board to consider all these dynamics, mm-hmm. because again, the law keeps changing. Every day Parliament rethinks the idea of how the law is structured and how the law is applied. So yes, in children custody and maintenance, the most important legislation is the Children's Act of 2022, but it draws its legitimacy from the Constitution of Kenya, Article 53 of the Constitution, yes.
Right. Now, the fact that you have the background on that, allow me to also have the viewers, wherever you're watching us from, talk to us. And our question for the day for you is, what is your view on the laws of child custody, the whole child custody laws in Kenya? What is your view on the same? Call us live 0795 045 864 and tell us. Probably just ask Wakili here any kind of questions that you have on the same. You're probably in the whole legal battles on the same and you really need some tips, or you're probably foreseeing the same on that. Number 2047 is our SMS number at TV47KE on Facebook. We'll be having that question there. You can go there and interact with us. We'll be sampling some of this feedback as we continue. So Wakili, the fact that you've told us what the whole background of this, also telling us the whole Children's Act 2022, as well as mentioning the Article 53 of the Constitution. So what are the different types of child custody?
Now, child custody, of course, as understood in the common usage of the language, is the idea of having the child within your possession. But now, from a general legal perspective, child custody could be in two important forms. Mm-hmm. When divorce happens, Stanley, normally children are a collateral of that divorce. But the interest of the child is always paramount above the divorce that has taken place in a court proceeding. So what normally happens is that any of the parents can apply for actual custody. Actual custody means that you will actually be having the physical possession of the child, wherever you stay, whether it's the mother or it's the father. There is another, level of custody. So that one is actual custody. Then there is the legal custody, where the child is not really within your actual position physically, but still you have been given the mandate to access the child by law. The court of law gives you the mandate to always access the child once in a while, always go and look at the child, although that child will be living with the other parents. And that also goes into the idea of taking responsibility. So custody also comes with maintenance. Somebody may have the actual possession of the child, but then you have been given responsibility by a court of law to always access the child at different times. So there's the legal aspect, the legal custody itself, where you are not in actual possession. But then there is the actual custody where the child is with you, living with you there in the house.
Right. So this means, because we really see quite a number of cases of the joint kind of custody where the partner, both partners, let's say if it's a couple, they probably split up. They probably don't live alone, but then they have a joint, child custody. And there are other cases where one of them has the sole custody and the other parent is not even allowed to see this child. There are also cases where one of the parents has the sole custody, but then the other is allowed by the court to have some access once in a while. And all that. Tell us how some of these cases apply.
So ordinarily, what the court normally does is that parties may decide to sign what is called a parental responsibility agreement. A parental responsibility agreement will always have two parts. There is the part of custody and the part of maintenance, which I will talk to later on. Now, on the part of custody, as you have rightly said, there are instances where the court will give sole custody of a child, whether actual or legal. Mostly the court will give actual physical custody of a child to one parent. In that circumstances, we will say that that is sole custody, because it's only one parent who is having the physical custody of the child, and the other party is completely blocked away from access to the child. Then we have joint custody in circumstances where one person is actually having the physical custody of the child, but variously in different circumstances, or periodically, or once a month or twice a month, depending with the prescription that has been adopted by the court in terms of the agreement. The other party, the other parent, will always have access to the child, go out with the child on weekends, visit the child, take the child out for lunch. So in such circumstances, we talk about joint custody, because although one parent has the actual custody of the child, the other parent has been given an opportunity, periodically or occasionally, to have time with the child. So yes, such circumstances arise. And there are circumstances where the court will make a determination that there is sole custody of the child, and the other parent should not be able to access the child. And mostly it's because of also safety concerns. The court will always look at all the surrounding circumstances around the best interest of the child and make a determination on whether the court is going to give the full custody of a child to one parent, or the court is going to allow access by the other parent.
Right. So for someone who's watching right now, so that they can also understand this process, they're probably going through all this, and they really want to have the child custody maybe for themselves, or just probably, again, the whole sole custody, maybe a limited access, for example. Walk us through the whole process of either one of these parents, either the mother or the father, so that they know this is how I'll go, before we actually now dive into what you talk about, the whole parental agreement responsibility and how it's signed and all that. Walk us through that whole process of, first of all, realizing that you actually need the child custody to the end.
That's very important, because again, Stanley, a lot of divorce proceedings take place, and most of them are informal, for those ones which don't go to court, where people, they just separate and they don't get back together. Now, normally what would happen is the question of custody only arises most of the times when divorce proceedings have taken place. So normally, the question of child custody will not be handled together with divorce proceedings. The family court will deal with the divorce. Then once divorce is done, a party who wishes, a mother, a father, the man, the lady, who wishes to make an application to have either sole custody of the child or to be allowed to have, access to the child, normally what will happen is you will make an application, which is quite separate from the application for divorce and all these things. If you look at the Children's Act, Part 9 of the Children's Act provides the whole process of how to make an application, for custody from Section 101 up to Section 105. There is a whole cascade of events there on how to make an application for child custody.
Child custody, okay.
Ordinarily, once divorce takes place and children remain as collateral of that divorce, a party will always go approach an advocate of the High Court of Kenya and make an application regarding, the children that are involved.
So in this case, who is supposed to make this particular application of the petition? Does it have to be solely the parents, or the mother or the father, or someone else can also file an application to have child custody as much as they're not parents?
Definitely. Part 9 provides that, a guardian could also, come in. And there are circumstances where the mother, the father may not be, really interested in the plight of the children that remain after the divorce proceeding. And therefore, a guardian will always step in. A guardian can step in. A guardian is also allowed, under Part 9 of the Children's Act, to come on board and make an application to court and ask the court that, look, I want to take care of this child in this prescribed format, and it is for this reason. Of course, the main consideration being still the child best interest. It's also interesting to note that in other circumstances, the court may allow anybody who has been in continuous, stay with the child for at least 3 years before the divorce proceedings, so 3 consecutive years before, to make an application. Although they may not be a guardian, although they may not be the father or they may not be the mother, the Children's Act will still allow you to make an application if you can justify that, 1, you will comply with all the child best interest, and that, number 2, the safety of the child, the idea that if you don't step in, then there cannot be any remedy to take care of this child.
What was the reasoning behind the 3 years, by the way?
You see, the 3 years is a policy consideration. And the policy consideration was given to 3 years because the idea that the Parliament wanted to entrench is that if at all you have stayed with a child for a certain continuous timeline, then it is highly likely that you are likable by the child, or that you know the details about this child, or generally for compatibility, processes. Because again, the child best interest goes into so many things. It goes into the safety of the child, it goes into the health of the child. So ideally, you would expect, ordinarily, Stanley, that somebody who has lived with the child for 3 years consecutively,
at least at least where this child goes to school.
Definitely,
blah, blah, blah.
You have a bit of details on the day-to-day running of this child.
All right, fantastic. So now you've taken us through. So this person, either the mother or the father, or maybe a guardian, files an application for the child custody petition. Now, after that, probably one of them or both of them do not really come to an agreement on saying, well, I do not agree that you will be the one to have sole custody. I'm also very fit, I'm financially stable, and we'll get to that. So how does the whole mediation of that, and now where we'd actually talk about the parental agreement responsibility. So how much of a say does the court have when it comes to this parental agreement responsibility? It's the two parties, either the mother or the father, or maybe even the guardian, sitting together and writing this responsibility and saying, fine, you'll have the custody, I'll also have the custody. But then what if they don't actually come to an agreement?
Stanley, what normally happens in children disputes, especially the Kenyan court practice, the Kenyan court practice has entrenched a lot of the idea of alternative justice, systems. So normally when you go to court and there is a dispute about child custody, the court will not ordinarily allow parties to go to hearing if they are not if they are not in agreement on who is supposed to take custody, who is supposed to take the actual custody, who wants access, and all these things. Normally the court will always give you an opportunity first to look at alternative ways of agreeing on this matter amicably. Once you agree, you come up with an agreement. That agreement may be adopted or rejected by the court. And you asked a very fundamental question. What is the role of the court in all this process?
Yeah.
I want to let you know that the principle of the child best interest under Article 53 of the Constitution is strongly guarded by the courts in Kenya. And therefore, unlike all the other disputes where parties will always agree and the court makes an adoption of the agreement, the court has a supervisory role to ensure that the agreement that you have come up with, that is if you really agree, if you're given an opportunity and you agree, the court will always interrogate the contents, the entire contents of this agreement, to see if these contents are compliant with both the Children's Act of 2022 and the Constitution of Kenya, Article 53 of the Constitution. Now, if ordinarily you don't agree, the court will allow you to present your arguments. The man will present the arguments, the woman will present the arguments, or perhaps probably the guardian, in absence, because there are also circumstances where there are one or two or more guardians, and then there is a conflict. Again, Part 9, from Section 101 of the Children's Act, 102, 103, provide circumstances where the court will always determine, in circumstances of a conflict between guardians, the court will make a determination. Once all parties have submitted their arguments, the court will then decide, again, what is in the best interest of the child, who is to be given the actual custody, who is to be given access, or whether the court can ordinarily just allow joint custody or the court can allow sole custody. Whatever the case. So the court has a supervisory role. The court has a supervisory role in the process. You agree, the court has still to interrogate what you have agreed on. You don't agree, the court will listen to all of you, interrogate the issues that you are presenting, the reasons you are putting forth to take custody of the child, and then make a decision that is in the best interest of the child.
All right. So that's the whole process therein on the same.
Yes.
And one of the, earlier on you told us one of the considerations that the court would make for the child custody would be age. And I mean, for years, men are always, have always complained that why is it that the women would, the court would be sidelining to the woman and the mother on having the child custody for her, and particularly when this child is, young. Around 9 years and below, and around all that, the whole tender years. Tell us why this reason. Because in 2022, it was a whole sigh of relief for men.
Yes.
Because I remember around the 4th of April 2022, Justice Ngugi saying that men can be granted the custody of children under 9 years. And according to the justice, saying that parental responsibility shouldn't automatically go to women. How does this now change the dynamics of the child custody laws? Before 2022, before Justice Ngugi made this ruling, how things were done, and what this ruling actually means for the whole age factor?
Thank you so much, Stanley. I must first begin by saying that if you look at the history of our Children's Act and the entrenchment of the idea that children of tender ages will automatically remain with their mothers, the history of our Children's Act dates back to England. So we ordinarily, after independence, adopted laws that were passed, completely borrowed, that were passed in England, and they began applying to us. I mean, they began applying to us. Never at any point have we had a serious discussion, until on or about 1995, 2001, 2016, about how we want our Children Act regime to run. So the consideration that we borrowed, the tradition that we borrowed, is that ordinarily mothers have the best instincts to take care of infants or children that still need special care. That is what was ordinarily provided for. Now, come to when we adopted the Children's Act of 2001 that applied until on or about 2022, when it underwent robust amendments from Parliament. Again, it provided that automatically, children of tender ages will always stay with the mother. They will always be under the special care of their mother, in the entire process of custody. To 2022, when Justice Professor Ngugi made that decision in Nakuru, the good judge was making an argument that we need to break off from this idea that automatically children of tender ages will always remain with the mother. And the judge was making this decision on the background that, indeed, in all fairness, if a reading of Article 45 would say that as at the time you are entering marriage, during marriage and after marriage, there is equality of parties. And so if there is equality of parties, that equality of parties should extend even beyond when two people have divorced. So the judge was basically making the argument that, look, it is not all the time, that an assumption is made that men generally are not able to take care of children who are of tender years or children who need special care and special needs. Now, Section 8 of the current Children's Act still entrenches that position. It goes ahead to say automatically mothers will take, care of children of tender ages unless the circumstances, do not allow. And the circumstances they do not allow is that in circumstances where the mother is unfit to take care of the child of tender ages, where maybe the mother is exceedingly, abusing drugs, And the background of that ruling also is very important. You know, the background of that ruling is that the mother was in the United States of America. The father had stayed with the child for 6 years. So when the mother relied on the automatic taking care of custody, Justice Professor Ngugi, you know, considered so many things. He considered the fact that, well, if you have lived with this child for the last 60 years, as a man, then ordinarily means at 9 years, you are able to take care of this child, notwithstanding that the mother is, you know, also demanding automatic custody. So the point that Professor John Ngugi was passing in that ruling is that today, as we speak, it would not be an automatic, as a matter of automatic right, that a child of tender age will always go to the
will go to the woman.
Yes.
So speak on behalf of the many men out here who are listening to you.
Yes.
And so they're wondering, so after this particular ruling, so does it mean that as much as even the mother is fit mentally and well, she's okay financially and everything, what are the chances of this man getting custody and even sole custody of a child who's below 11 years?
Stanley, I can say the chances are very high. That's what I can say. I can say the chances are very high. Because if you look at the analysis of the judge was also, you know, impliedly saying that although the rule has an exception that, you know, where the mother is unfit and all these things, ordinarily, under all circumstances where both the father and the mother is okay, then the rule can be said to be discriminatory. You know, that is what Professor Ngugi was hinting to, that the rule can be said to be unfair. So the court actually reached a determination that in circumstances where custody is sought, even of a child of tender ages, the court must look at all the circumstances of the case and make a determination. If, for instance, Stanley, the father has proven that he's able to take care of the child, the idea of the automatic matter of right of custody of mothers will not then come into play.
So let's talk about the major party in this whole disputes and everything, the child himself or herself. Because the Constitution tells us that a child is, you know, someone below the age of 18. And technically there's a whole bit of this person doesn't have the whole is sound-minded and all that. You can, you know, broadly tell us about that. So how much say does this child have when it comes to his own or her own custody?
That's a very interesting question, Stanley. Ordinarily, the assumption that people make is that children have no proper, you know, development of the mind to make very pertinent decisions about themselves. But that is what not the child best interest is saying. The child best interest is saying that ordinarily, even though you are to make a decision on behalf of the child, you have to consider the views of the child. Actually, let me tell you, Stanley, even in terms of custody, what the courts have said under the Act entrenches, the Children's Act of 2022 entrenches, is that the views of the child must be taken into consideration. I have seen cases active in court or cases that have been finalized in court where the child explicitly narrates the reason why they don't want to stay with the mother. They explicitly narrate how the mother have been mistreating them. They explicitly narrate how the mother sometimes comes out, you know, to the house shouting and all these things. So the idea that children cannot make decisions of their own, I think is debunked through the entire, you know, concept of the child best interest. Whereas you can consider other factors as a guardian, whereas you can make decisions about the child, what the law sought to demystify is the automatic assumption that children are not able to make decisions on their own. They don't know what is best for them. And that is why even in custody, the views of the child must always be, you know, be sought after.
But how solid are they? Because you take a look at, let's say, an 11-year-old child. As much as they might really be telling the truth, they tell you that, well, the mom she comes back drunk and she harasses me, but then there's no other witness in this house. There's probably a whole other facade that this mother will have with a son or daughter when she's out there with her. But then in the house, it's a whole other different situation. So how much of this bit that the child is saying will the court really pick?
By the way, Stanley, and I think that question stems from the idea that many people have conflated these two concepts. the child views is not necessarily equal to the child best interest.
Okay.
There are other circumstances where the child will, give his or her view of a matter of how he wants custody to go.
Okay.
But then the court nevertheless will reach a conclusion that may not be in the best interest of the child. So the views of the child ordinarily is not to be substituted to mean that is equal to the child best interest.
Okay.
The best interest of the child, and I would give you an example. In circumstances where evidence has been put on record in a court of law that the mother has been very abusive and abusing the child, and the child, for instance, has physical scars, but nevertheless the child goes ahead to say, well, I still want to stay with the mother. Whereas that is the child view, as at that particular point, is not necessarily equivalent to the child best interest. So the court will look at the totality of circumstances and make a determination of what, it would really be to refer to a child best interest. So a child best interest is not at all times. Sometimes it may be equal to the best interest of the child, but not all the times the views of a child over concerning a particular matter will always be equivalent to the best interest of the child. In fact, ordinarily, if that was the scenario, then we would not have the parents come on board, we would not have the guardians come on board, we would not have people, coming as their representatives in court proceedings, because ordinarily we will agree that, well, they can make decisions over everything. And the reason why we can also not take away the totality of the views of the child is because the views of the child is part and parcel of the development of the child. What makes the child happy might not be what makes the parents happy, might not be what makes the guardian happy. Yeah. So the court has to look at all these concepts and make a very firm decision that in totality of circumstances, for instance, the employment status, of the parents. A child cannot, for instance, wants to stay with the mother who has nothing completely to take care of her,
But then, because I think around the same year, 2022, the Supreme Court, the case of Mutheu Agatha and Rahim Mehdi, reiterated that the best interest of the child is a key determining factor concerning the children. So the best interest of this child. So what if the best interest of this child is to stay with the mother who this child, the son or daughter knows that I am perfectly okay. My mom doesn't have a job, but I'm perfectly okay with my mom. What if, does the court look at, as long as the child, the parents and the guardians can't really be happy with the decision, but at the end of the day, is that the court's thinking that at the end of the day, this child has to be happy completely? As much as whatever decision it will make won't really please the other parties, but at the end of the day, the child has to be the one who has been pleased. Is that the case?
Definitely, that is the case. But I still want to take you away from the idea that what the child wants is equals to what is the best interest of the child. Okay. Actually, it's also important for me to give the background of why the court was making that determination.
The Supreme Court's case.
Yes, the Supreme Court decision. The Supreme Court decision came out of a marriage that was domiciled in the U.S. The Supreme Court decision came out of a marriage that was domiciled in the U.S. Understandably, there were 35 proceedings in the same matter. 35 proceedings. Some of them in the U.S., some of them in Kenya. The court went ahead to make a determination that, look, whereas the mother has gone to court that several times, this conglomeration of suits and court disputes has a mental effect on the child. Okay. Because the child that was consideration in that case was a 16, 17-year-old. Yeah. So the court was of the view that this multiplicity of suits, Stanley, may not be, in the best interest of the child. It was a whole circus where the father goes to court, gets custody, the mother goes to court for review of the same order, the father gets to court, he turns back to Kenya, he goes to Tanzania with the child, the father is not able to get access. So in that circumstance, the court, for instance, made a decision that multiplicity of suits, in the same matter, that concerns the child, is not in the best interest of the child, because it will always take a mental toll, on the children. So ordinarily, if a child wants to stay with the mother and the mother has no capability of taking care of the child, but then nevertheless the child insists that I want to stay with the mother, well, the court may end up granting it. What will happen is that now, in terms of maintenance, the court will give a responsibility to both the parties. you know, both the parties in terms of school fee, in terms of shelter, in terms of food, in terms of clothing. So the court can still ordinarily grant the order, notwithstanding that the mother has nothing, you know, to take care of the child, but ensure that in the parental agreement, the other party is able to come in and support in a manner that the mother may be providing a lot of moral support, a lot of psychological support, taking care of the child, you know, ensuring the child is prepared for school.
Well, on the other hand, the father keeps...
So the court will always, strike a very delicate balance. And by the way, Stanley, on the matters of children, courts are very strict. They don't leave anything to chance, because also the Constitution recognizes children as part of the vulnerable.
All right. And that answers a couple of questions on the same, the whole financial status. I think actually most of the guys asking, does the financial status really matter on the same? I think you've really touched on that. But then now, for this case, before we actually get into the whole jurisdiction, because you've mentioned it quite a lot on both cases, where Justice Ngugi's ruling as well as the Supreme Court case, where it involves Kenya as well as other countries. During this court process, first of all, you can tell us how long should this court process, because at the end of the day, it involves a child and the mental health of a child. So bringing the child to court and all that can really be tiresome. So how long should it really take? And the second one, during this whole court process, to ensure that this child has a custody at the end of the day, where is this child at the moment? Who's under custody of this child? Because the parent, both the father and the mother, are fighting for custody. But during that process, who is taking care of this child?
I think I need to start with the last question and then go back to the whole issue that you asked me about how much time this is supposed to take. Stanley, when the moment divorce happens, usually it is one parent who will be staying with the child.
Okay, now in this scenario, because you'd find a number of times the parents didn't even actually get married. They were probably just dating, and then a child was conceived during this time. So they were not actually even legally married. So there were no grounds for divorce.
I think unfortunately so, Stanley, most of the times the burden of remaining with the child or staying with the child remains with the mother.
Okay.
Most of the time the burden of remaining and staying with the child always remains with the mother. In circumstances where the father, remains with the child, ordinarily what I've seen from practice is that mothers do not always want to contest, especially if they don't have the financial muscles to take care of the child. But most of the times, it is the fathers that leave the mothers with the children. So that...
During that period of the court battle?
Yes, it is always during that period of the court battles. So, actually, I want to answer all...
Kindly, let me interrupt you a bit. Hold a thought there. Let's pick this call.
Okay.
By Shem kutoka Kapsabet. Okay. Shem, habari asubuhi?
Niko salama, ujambo?
Asante sana for calling us right here. Uko na swali au maoni?
Niko na swali.
Uliza.
Nimeona mwanasheria pale akijaribu kufafanua mambo kuhusu watoto.
Yeah.
Kwa hivyo swali langu kwanza ameongelea mambo kuhusu the financial status and what have you, where the court can grant custody of the child, either to the father or mother. But in this situation whereby you raised the issue that the mother is not financially stable, but the child still insists to want to be with the mother. Then kuna kitu wamesema pale. Kwamba the court can allow that, but then it comes to mambo ya kumlinda huyo mtoto, babake anaweza shughulikia.
Okay.
Kidogo wagawane. So langu linakuja hivi, kwa mfano huyu mwanaume akiwa ako na mke mwingine na watoto wengine, alafu ikafanyika kwamba akapata mpenzi mwingine,
yes,
wakapata mtoto.
Okay.
Alafu wakaenda paka kwa koti because of the custody of the child.
Okay.
Alafu mama hana kitu, is like a housewife, kama penye yako pengine na mfanya biashara tu.
Right.
Alafu wakasema anaweza kaa na mtoto wake.
Right.
Then the court says that now the father can now share the cost of taking care of the child. Na anafanya kazi. For example, it's a civil servant. This civil servant earns maybe 120,000 per month.
All right.
There's this situation whereby the lady will say that I want 70,000 or 60,000 to take care of one child. And sometimes we have seen the situation whereby the court grants that.
All right.
But if I have 5 children with one woman and I have one child with the other woman,
all right,
is it possible for the court to be fair enough and say now, if the father is earning 120,000,
okay,
the amount of money earned be divided proportionately to the children? For example, there are 6 and I get 120,000.
okay.
120 divided by 6 gives me 20,000 per child.
Okay.
So if a woman says that I need 70,000, what about the other 5?
Okay.
So there's that challenge whereby I've seen a situation whereby the lady who has one child wants to take everything from the man just because I asked that, and sometimes the ladies take advantage of the same and harass the man. Kindly, I would like to hear the response from the expert.
All right. So you basically want to know if the court takes a look at all this math and even shares the whole responsibility of your child support.
Exactly.
Sawa, asante sana Shem kutoka Kapsabet. Salimia sana watu wa Kapsabet. 0795-045-864 is the number to call us live. When you're calling, tell us your name, where you're calling us from. GOtv, just have it off and ask or give us your comments as audible as possible. Before we get to human and how long it takes, you can answer Shem, human and parent responsibility. He had a very loaded question. Alikuwa amefanyia hesabu yote hapo and he's very curious.
Stanley, you see, I listened to that question and ordinarily that is what happens to Kenyans. Very complex scenarios of, on the ground that the court then has to make a consideration of. But I think what I need to tell, Shem, is that the court will only deal with the question of the child placed before it. If you have 4 children with another woman, and you have one child with this other woman, and it is this other woman who goes to court, the court has ordinarily no mandate to go into the question of the other children and whether they are maintained. Their question only comes to the fore if one party goes to court. Okay. If one party does not go to court, the court can only consider that you have other children as a matter of evidence, but will not go deep into finding out how many children are they, what do you do with them. No. If it is the question of one child that has been brought into a court of law, the court will deal with that, particular question of that child. The other children that you have, whether they are 7, 10, or 12, the court can only consider them to give weight to the idea that you are making an argument that I have a bigger burden, to take care of, and the court should be considerate on me. The court should, consider equality of parties. The court should consider the fact that I'm not able to support this and this and this. But the court will not ordinarily go into an inquiry of how many other children do you have, what is their status, are they being taken off. The court will deal with the child concerned, the child whose case has been brought before court as at that particular time. The children of the other woman will only come to the fore of the court process if the other woman or one party goes to court, challenging their custody or the manner in which they have been maintained. So ordinarily that is what the court will do. The court will consider that as a matter of evidence. The court does not go into that inquiry unless you have these two women, all of them in court, then the court will, balance of what are your financial status, what are your prospects at work, employment, and all this, and, share responsibility with the mother.
With the mother, okay.
On timelines, there is no defined timelines in which all these matters need to end. In fact,
Actually, now on that, because I know it's a whole broader bit, I want to take a short break. So that after the break, you can tell us more about that, and particularly the whole financial bit. Because here, Shem was talking on behalf of so many men who are in this predicament. So yes, 0795-045-864 is the number to call us live. We're taking a short break, but then, usijali, anza kuweka credit as early as right now, because when we come back, we'll be filling all those questions that you have as we discuss matters of child support and care. And we're asking you, what is your view on child support, rather the whole child custody laws in Kenya? Have you experienced this? Tell us your experience also as you call us live. 22047 is our SMS number, at TV47KE on Facebook. Don't go too far. whole child support. In studio do have lawyer Evans Ndong, and before the break he told us the whole process of filing child custody until all that, even for both partners having a parental agreement responsibility and really understanding who is going to have the joint custody, who is going to have a sole custody and all that. Also, before the break, we had a caller, Shem kutoka Kapsabet. He had a whole complex question on how the shared responsibility really come in and matters support. And for him, asking if this man has another wife out there and other children, what considerations does the court have when it comes to the financial responsibility? How much? Hadi akapiga hesabu akasema if this man is a civil servant earning about 150k per month, how much is that divided by court? And you had started giving us an explanation on that. But then for Shem's case is really quite complex. And you told us that, well, the court won't really consider, in fact, of those children who are not before the court. It's concentrating on the child before the court, on its custody. But then now for a simple kind of situation, a scenario, which many men out here are really facing. You having that one child. And because earlier you told us that the woman, let's say the child decides and says that I really want to stay with mom. But then mom doesn't have a steady job. So mom is depending on, because again you told us that it's an equal responsibility. So mom gives the moral support and everything, and then the father chips in on the financial bit largely. So for that bit, that this child is before the court, how does the court factor in? Does the court come and sit down and say that you, father, kama unaitwa Charles, you earn this amount of money, this is what you're going to be giving, this percentage, this is what you're going to be giving per month to the mother. How does that work?
Thank you so much, Stanley. Normally, the court will look at the employment status of either party. The employment status of the man, the employment status of the woman, before it makes such kind of determinations, especially the ones that involve, financial contribution or contribution of one party in terms of money. So ordinarily, when you go before a court to seek for child custody or maintenance itself, you will always specify the amount of money that you want the father to cater for in terms of school fees, in terms of clothing, in terms of all these things. And it must ordinarily be remembered also that all these applications or prayers to be given this particular amount to depend on this particular amount will always also depend on the life that you put the child on prior to the divorce. That is also very important. The courts have considered that if you put, for instance, a child in a particular standard of life prior to divorce, there is always a legitimate expectation that they will be maintained, in that standard of life. So, custody applications are always continuous working processes before the court. Whereas the court can make a determination that the father needs to give 30% of the school fees, 20% of the school fees in this and this amount, what you pray the court to give is not cast on stone. The court can vary it depending with the employment status of any of those parties. Remember also that if on the way, in the pendency of that order being executed where the father is maintaining the child at 30% or 40% or 50% or whichever amount, 20,000, 40,000, the other party can go back to court for the review of the order. For instance, if you realize that the mother has gotten a job, along the way. So it is always...
so the father can actually now go back to court and say,
yes,
you told me to give 70%, but we have a job, so nipunguzie percentage yangu.
Yes, as at the time is given, it was not employment, now is in employment. Other circumstances, the child has changed schools. So really, ordinarily, the amount of fees will vary, or the parties have relocated to a different estate, a more expensive estate, depending with the status you put the child before the divorce happened. So a custody and maintenance order is always a reviewable order. Circumstances of the child will always change at particular times. So that order will always remain within the supervisory jurisdiction of the court throughout, because the court will not take it as static as possible. Sometimes the order was made when the child was 16 years. Now the child is 18 years, he's finished school, he's gotten something to do. The court will consider all those things. And remember, Stanley, I also need to point out that courts have told us, and the Children's Act reinforces that position, that parental responsibility can go beyond 18 years, especially for those people who attain the age of 18 years and they are still in school. Still, the law will require you to take parental responsibility. One thing that Shem alluded to that I also want to comment about is that the idea that you have married another woman or you are in a different union is irrelevant when you are talking about, you know, child custody and maintenance. The best interest of the child will not require a marriage to be in place for a man or a woman to take care of the child. The plight of the child will be looked at regardless of whether the marriage is on or is not on, whether you are together or you have gotten a different woman. Those relationships, those engagements, those marriages do not in any way affect the position of the child, because as I said, the constitutional, you know, framework recognizes the child as a vulnerable, you know, group of persons that must be taken care of throughout. So I think that is important. So we don't have a specific timeline that I can say this children matter will end at this particular time. Okay. It will always be, especially on custody and maintenance, it will always be reviewable, because custody also changes. Sometimes the court has ordered that the man, you know, surrender the child to the lady. They have refused to do that 2 or 3 weeks later. Somebody goes back to court and says, cite this person for contempt of court orders. On this day we had an application. You gave us these orders that the child should be transferred to the mother. The father has refused. The court will review its order. So it's dynamic.
Is that a gap in the law, considering the fact that this can really have a huge toll on the mental health of this child? This child just knowing that there's a whole court battle just for the custody of someone taking care of me?
Definitely, especially if the child is not of tender ages. 16, 15 years, it usually takes at all. Actually, that was the position in the Mudeo Supreme Court decision that you alluded to. In that Supreme Court decision, the Supreme Court was very emphatic that the best interest of the child does not support this multiplicity of suits across all courts, where you file here, you file there, and you file. Because you see, also remember, Stanley, that where you will file custody and maintenance also depends with the religious applications of the child at times. Because Muslim children will always move to the Qadhi's court, you know, for that matter, you know, independency of their matters. So ideally, there are circumstances where it takes a high toll. You know, children of tender ages, it might not affect them as much because they only know the father, they meet the mother, they don't know ordinarily what is going on in the substantive manner. But the mental health status will always get affected, especially when they know the father wants to stay with me, the mother does not want. And sometimes these things involve even exchange of verbal abuses in the process. So it can really be murky, and it's a problem that, you know, that is beyond law. It's about enforceability and society. And by the way, that is why even custody and maintenance...
So probably it's a gap.
It's a gap. That is why in custody and maintenance, there is always a consideration that the Children's Act has brought on board, that the society in which the child has been brought up has to be considered. Remember, Stanley, there are societies that still own the child as a communal property. Everybody will always get in to take care of the child whenever there is a gap. The court has to consider all those factors, whether to make sole custody or joint custody.
And another fact that we've understood that a bit, let's talk about and tackle the different kind of considerations that are there. First off, Jessica kutoka Bondo was asking in our comment section, ameolewa kwingine, je, anaweza leta mtoto wake wa kitambo kuja kumlea hapo? You can tell us more about that. But then also, because you told us that the court takes a look at this child before the court itself. So what about, let's say, the siblings of this child? The father and the mother had, let's say, 3 children, but then they're fighting custody for this one. Probably it's the one who's way younger, maybe 9 years, 8 years, around there. What considerations does the court make when it comes to even the siblings of this child? Do they really matter? Because this child might really be inclined to want to stay also with the siblings. Tell us about that.
Stanley, I will begin with that. Again, that is catered for. Section 101, 102, and 103, Part 9 of the Children's Act. Part of the consideration is also the views of the siblings. What is their position on this matter? And this is critical because in certain circumstances, Stanley, you'll find that part of the siblings are people who are grown up, they have gone to school, they have jobs, they stay. So the court will always make all this consideration, and then the child in question before a court of law is one of tender ages, or is a minor, or is still in school, or has not progressed in terms of education and all these things.
Right.
And sometimes the reason why that also becomes very important, it must be remembered strongly that the responsibility to take care of a child is parental. So ordinarily one cannot argue that, well, why can't your other siblings, take care of you? Why do they want me to take care of you? Yeah. So the views of the siblings are very important, especially because also they know the father and they know the mother. So the court can also give some weight, to that. Yeah. But remember, the contest before court is not whether the siblings to take care of the child, it is the parents. So the views of the siblings will only go into the root as to whether they support a joint or access or sole, and also as to whether they feel like the mother should take care of, and they could also give history of the character of the mother or the father. Right. The court will consider the totality of that in making a determination. Right,
fantastic. So as we wrap it up, just to answer what Jessica was talking about that, your final thoughts in a sentence, your advice to someone in all this, then we tufunge in a sentence.
I will answer Jessica in 1 minute. One, whether you can bring up your children which you had in a previous marriage, yes, you can. What will happen is, if the man accepts them, if the man accepts to take their responsibility, the law will automatically come in to presume that he has accepted them as children, and therefore will be in need of taking care. My parting shot is that I think the idea of custody and maintenance is one that needs to be embraced by all Kenyans. There are so many informal engagements outside there in the villages, in the rural areas, where most people do not know about this. I just want to say that the law provides a very clear framework in which you can go and apply for custody, and